Retired Constitutional Court Justice Edwin Cameron joins us now for more on the Constitutional Court marking 30 years of existence. Former Justice, thank you so much for your time this evening, Justice Cameron. Of course, yesterday we saw the Constitutional Court celebrating 30 years of existence. Maybe let's start off here. I mean, what do you make of this major milestone being achieved in the country?
It was a major milestone, and first of all, I'm very pleased to be with SABC and its viewers, but it was not a triumphant occasion. It was an occasion which was dampened by the realization that our Constitution and all of us who are said to safeguard and implement it haven't done well enough. We haven't done enough good. So it was a wonderful occasion, and we have much to celebrate in the enactment of the Constitution. It is a forward-looking Constitution. It's a generous-spirited Constitution. But all of us should be doing much more. There are many unfulfilled promises. And that was the significant thing about yesterday, which is that both President Ramaphosa and Chief Justice Meyer pointed to the shadows. They didn't just say how wonderful Constitution, wonderful ConCourt. They said that there are shadows, there are the president was quite explicit, actually. Non-functioning departments, corruption, dysfunction, failure to fulfill promises and to deliver. So that was the tone set. It was a glittering occasion, but also an occasion for reflection.
And Justice Cameron, as we continue to reflect on this historical milestone for the country's democracy, what would you say, the Constitutional Court has had to overcome in terms of challenges to actually be in a situation or a position to reflect back and mark this occasion?
I think the court has achieved a lot. The court, and there were several members of the first court, all appointed by President Mandela during 1994 and 1995, and the court had its first sitting in February 1995, so that's 30 years ago. The first court had to create an entirely new jurisprudence, and it had to reset South African law to be a law of transformation, a law of looking back at the terribly, the horrific injustices of the past, but also looking forward to what we should be doing to create social and economic rights for our people, housing, education, healthcare, all of those. So the ConCourt's first tasks 30 years ago were huge. There have been significant achievements. I think, for example, the Treatment Action Campaign judgment was a significant milestone. I myself have been on antiretrovirals for almost 28 years. It's a good news story. But I got those antiretrovirals when I could pay for them myself because I had the salary of a judge. Through the Treatment Action Campaign and activism, going to court, fighting the drug companies, and necessarily fighting President Mbeki, the Constitutional Court gave an extraordinary judgment that said to President Mbeki's government, you've got to start delivering antiretrovirals now. And it's a success story which inspires all South Africans. We now 7 million people like myself whose lives every day are owed to taking a simple antiretroviral tablet with 3 medications in it. So that's a big achievement of the Constitution, and there are many other judgments that are also pivotal judgments, landmark judgments, which changed our democracy and changed our history for the better.
And Justice Cameron, I mean, you also talk of the future. Well, you say that it was a glittery occasion, but you admit that there are challenges, that the Constitutional Court is still presented with. Maybe let's try and talk about those challenges. What challenges still persist in the court that need urgent intervention? Some would even say that the issue around direct access of the Constitutional Court is something to highlight.
Yes, I think that's been a persistent criticism. The idea behind the Constitutional Court, and both in the transitional constitution and the final constitution, was that there should be direct access, whereas the court has been quite wary of granting direct access. Now, I believe that's for good reason, because you go to a high court, the matter is argued there, you figure out your papers, you figure out what your case is, and then you come on appeal to the Constitutional Court. So I wouldn't criticize the court for being careful. It has given direct access. Just before elections, for example, it's given parties access to come and argue their cases. So in appropriate cases, the court has been willing to give direct access. More broadly, I would say that our failure to deliver, government's failure to deliver, for which the Constitution is often wrongly blamed, and President Ramaphosa yesterday rightly laid the blame for those failures of delivery at government, not at the Constitution. The rights are there. We should all be making a bigger effort to deliver them. And if I may speak of my own present role, I stepped down from the Constitutional Court 6 years ago, taking retirement, and President Ramaphosa appointed me as inspecting judge of prisons. We look at our prisons, they're far from perfect. They are terribly overcrowded. Overcrowding is a problem. There are other problems. There are structural problems with the delivery of structures and maintenance and rebuilding from the DPWI. And there are other problems which I believe are all remediable. There's no problem within the prison system or in our country that we, through our own efforts, cannot remedy. Let's think of corruption. With sufficient leadership, with sufficient determination, with the right people at the head of crime intelligence, with the right people at the head of the special agencies which are meant to fight corruption, we can stop corruption in our country. We can bring down the murder rate with effective law enforcement. So there's a lot that we can do in prisons policy. We can go back to the wrong turn that me and my co-authors in the new book on prisons that we've just released say was a wrong turn in the Mandela administration, when we thought that we could solve our crime problem through long sentences and through sending many people away for life sentences. That has been proven to be a terrible mistake. The answer to crime lies in effective crime intelligence. Since 2011, when President Zuma set out, I believe this is a fair and just comment, to destroy crime intelligence, to destroy the National Prosecuting Authority, to destroy the police through shady appointments. Since 2011, our murder rate has gone up. It has subsided a little bit this year, which is very welcome good news, but we are almost at double the number of murders that we had in 2011, when the Zuma years really started taking their terrible destructive toll. So all of that can be fixed.
Yeah.
We have the people, we need the leadership, and we can fix all of those issues.
And Justice Cameron, a bit earlier on, I mean, you touched on some of the landmark cases we've seen in this country, and you singled out the treatment action campaign. Maybe if you can also just give us a bit of insight when it comes to other landmark cases we've seen before the Constitutional Court that have had a significant role for the country's democracy.
One of my favorite cases is a judgment of my colleague, my revered colleague, Sisi Kampepe. And it concerned mine workers. You work for 20, 30, sometimes longer years in the mines, and then you're sent home to the rural areas in Mozambique or Lesotho or the Eastern Cape or Eswatini, and you've got a fatal lung condition, and you get 3,000 Rand compensation. That statute, Justice Kampepe, in the unanimous judgment of the court, reinterpreted to give mine workers far more compensation, to give them just compensation. And the result was that the mining companies had to set aside billions of Rand to apportion compensation to mine workers who'd given their lives to us to build our country, to build our roads through the profits that they reaped from mining. And that judgment made an appreciable impact on the lives of many tens of thousands of mine workers and their dependents. Another judgment which I think deserves enormous credit is the judgment of Chief Justice Mogoeng in the Nkandla case. It concerned a directive, a ruling that Public Protector Thuli Madonsela had given, which Parliament dismally, lamentably failed to follow up that, failed in their duty of oversight. The President failed, President Zuma lamentably failed. And what Chief Justice Mogoeng did in the Nkandla judgment was to really, I said he delivered a sermon, and he quite liked it when I said that, because he is a pastor, and he gave us a sermon. And this was a beautiful sermon about our duties as citizens, the duties of Parliament, the duties of the executive, and most importantly, the duties of President Zuma, which he had failed to carry out. Now, whether he was attentive to any of that sermon is something for the SABC viewers to decide for themselves.
All right, Justice Cameron, thank you so much for your time. That's retired Constitutional Court Justice Edwin Cameron there, just giving us his reflections as the country celebrates 30 years of the Constitutional Court's existence.